Hi, I'm Manny Fitzsimmons. I'm your Washington Realtors Legal Hotline Lawyer, and today is another video in our series entitled Real Estate Fundamentals You Should Know. Today we're talking about negotiations. Negotiations is once again one of those topics where we could spend a whole day talking, and for the purposes of this video today, we're going to talk about two or three very isolated issues within a very broad negotiation topic. One of the topics that we're going to talk about today is a question that comes up repeatedly with respect to listing brokers representing sellers in negotiations. Now, depending on the market in which you find yourself and depending upon your own personal preference for negotiation strategies, you will certainly make recommendations to your seller about the best way to negotiate, competing offers, or maybe if you're in a buyer's market, how is your seller going to compete or negotiate if this is the only offer they've got and maybe the only offer in the foreseeable future that they're likely to get. So you're going to tailor your negotiation strategy not only to your preferences but to the marketplace in which you find yourself. We're not talking about any of that today. Instead, I want to talk to you about what happens when buyer's broker, whether they're one offer or one of many offers, when buyer's broker says, tell me the terms of competing offers. Maybe you have other competing offers that you really could share the terms with them. Maybe you have no other competing offers, and then the question might be, do I want to reveal to them that I have no competing offers? Now, recognizing that every broker has a duty to all parties in all transactions, regardless of agency, to engage with honesty and in good faith. You're not going to lie or be deceptive or misrepresent anything. So I'm not saying that if you don't have competing offers that you would say you do have competing offers. The question is more fundamental than that. The question is, if buyer broker asks for information about competing offers, can you as the listing broker give that information? And the answer is very simple. And the answer is the same to every question, whether it's what are the terms of competing offers? Are there competing offers? How many competing offers are there? What's the highest price? Whatever that question is, the answer is the same. The question is, can I share that information with the buyer's broker? And the answer is yes, if seller has given you permission to share that information. You would never share any information about whether there are competing offers or the terms or price of those competing offers unless and until you have first explained to seller the pros and the cons of sharing that information with the buyer's broker. And if the seller says, no, don't share it, then your answer to the buyer's broker is, I'm sorry, I'm not authorized by my seller to share that information. If the answer is, sure, go ahead and share it, then you share the information that you're authorized to share, and you do so with honesty and good faith. Seller may not want you to share that information because some sellers prefer that buyers engage using their wildest imagination to come up with the highest price and the best terms that they can for their offer. Other sellers want to create a bidding war where they set benchmarks for buyers to meet by, this is how high the highest price is, can you beat it? Different sellers are going to want different approaches, just like different listing brokers are going to want different approaches. So you and your seller have to come up with the right approach. What I want you to understand as a fundamental is that you don't share information about competing offers with competing buyers until your seller has authorized you to share that information. The other discussion I want to have with respect to negotiations is when buyer and seller are going back and forth, when do we know that we have mutual acceptance? Let me give you some examples. Buyer makes an offer and seller says, I'm completely happy with the terms of this agreement, the price and all of the terms, except I want to make this little teeny tiny change. Maybe it doesn't matter how tiny the change is. Maybe they cross off one item of included items that the buyer wants to take with them. Maybe they change the identification of the escrow company. Maybe they change in the title review contingency, 22T, maybe they change it from 5 days after mutual acceptance to 5 days after delivery of the preliminary commitment for title. Whatever the change. If seller changes anything in buyer's offer, anything in buyer's offer, with two exceptions, it's a counteroffer. And we don't have mutual acceptance until buyer accepts those changes, no matter how insignificant the change may seem. What are the two exceptions? Seller can correct or add seller's name to the purchase and sale agreement. Seller can correct or add information related to seller's FIRPTA disclosure, the Foreign Investment Real Property Transfers Act, the FIRPTA disclosure on the face of the purchase and sale agreement. So let me summarize that differently. If seller's changes to buyer's offer include only the addition or correction of seller's name on the purchase and sale agreement, or the correction or addition of seller's disclosure related to the FIRPTA provision, then those changes or additions are not counteroffers. Any other change that seller makes to buyer's offer is a counteroffer, and we do not have mutual acceptance until buyer accepts seller's counteroffer, no matter how insignificant that change may seem. So in a competitive market where seller may get other offers and buyer broker, the seller sends back at what seems to be an acceptance of buyer's offer, except there's this one little change, buyer brokers, it's critical that you get your buyer's initials on that change and you get your buyer's initials immediately back to listing broker so that we do in fact have a binding agreement. Seller can't then withdraw their counteroffer and accept a competing offer that might come in a few minutes later. And when do we actually have mutual acceptance? Is it when buyer initials seller's counteroffer? No. It's when buyer's initials accepting seller's counteroffer are delivered back to the listing broker or the seller. Mutual acceptance is achieved when the final initials or signature from the accepting party are delivered back to the maker of the offer. So in the scenario where we were just discussing where it was a seller counter offer that buyer was accepting, then it's the date and time that buyer's initials or signature are delivered back to the seller. If it was the seller accepting buyer's offer, then we had mutual acceptance, the date and time when seller's final signature or initials are delivered back to the buyer broker or the buyer. If you have questions on any of these negotiation issues, please send an email to me. But remember that this discussion in this video with respect to negotiations is a teeny tiny discussion with respect to the huge issue of negotiations. And you need to learn how to negotiate a purchase and sale agreement if you're not already familiar with that. These are very isolated, fundamental issues within that broad spectrum of how do I negotiate a purchase and sale agreement. If you have questions on these topics or any other related to real estate law in Washington State, please send an email to me, legalhotline@warealtor.org. Thank you for being a Washington Realtor member.